Welcome to our presentation on the Court of Claims. Before we begin the presentation, I would like to acknowledge country. So, in the spirit of reconciliation, New South Wales State Archives acknowledges the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respects to their elders, past and present, and extend that respect to all Aboriginal and Torres Strait Islander peoples today. So I just want to emphasise before we begin that the Court of Claims is not civil court, it's not criminal court. We are talking about a court that was set up to deal with land grants. So it's land that we're talking about today. So the first question we're going to ask ourselves is, what is a land grant? Basically, it means the alienation of land from the Crown. When the colony was proclaimed in February 1788, basically they said that all the land was the possession of King George III. Therefore, only the Crown could sell or distribute land. Now, the governor was able to grant had the power to grant land to free settlers, convicts whose sentence had finished, or to military personnel. And the reason why they needed to do this was because they needed to feed the colony. At one point, it almost starved, so they needed to develop farming, they needed to develop rural industries so that the colony could be self-supporting. Now, the first Crown grants were issued as early as 1789. From memory, it's to James Roos to grow wheat, but they weren't registered till 1792. People tend to think that grants meant you got the land for free. Now, it is true that until 1825, all grants were free, but you still needed to have money. You didn't necessarily have to pay that money to the government, but the amount of money that you brought into the colony as capital governed how much land you got. If you only had £100, you got 50 to 100 acres, and you were able to house, feed and clothe 2 convict labourers, and then their work would be for your benefit. If you had £1,000, you got 700 to 1,000 acres, and you got 6 convicts to work for you. In 1825, the sale of land by private tender began, so now they're selling land, but they're still giving free grants until 1831. So it's not until the 1st of July 1831 that all Crown land was sold by public tender. Even with free grants, there could also involve what's called an annual quit rent, which is a minimum amount that you needed to pay to the government, usually described as a peppercorn. So what was the Court of Claims and why was it set up? Basically, before the deeds could be issued, the land had to be surveyed, and there was a backlog in surveying. So many people were given promises of land, but they never got the official title deeds. And this is the bit that I find quite extraordinary, but one of our memorialists will explain in a minute. But they moved in, they built houses, and they sold the land, all without having title deeds. So the Court of Claims was created by legislation in 1833 to hear and determine upon claims to grants of land under the Great Seal of the Colony of New South Wales. Primarily, it applies to cases that are about pre-1830 location for these cases when you're using these indexes, because it's the areas that are settled before 1831, primarily Sydney, southern New South Wales and the Hunter Valley. 3 commissioners were appointed on the 17th of September 1833 for a period of 2 years, and they thought that would take care of all the cases. And the hearings commenced on the 11th of April 1834. Not surprisingly, they didn't get through all their cases in 2 years, so in 1835 another act was passed to extend the process to allow it to continue. However, this time the claims could be referred to the court by the governor through the colonial secretary, and the governor did not have to accept the decisions of the court. This concept of having a court to assess disputed titles was judged to be valuable and therefore continued by subsequent acts. The Titles to Land Act in 1858, which actually tried to make the land descriptions in the old system more clear and accurate, and therefore disadvantaged some people, resulted in more cases. And then there's also the 1898 Conveyancing and Law of Property Act, and even the 1919 Conveyancing Act. These all continued the concept of the Court of Claims, and indeed the Court of Claims in the 1960s could still be used if necessary. So what was the process? Basically, the person who was claiming the land would write to the Court of Claims. These are known as memorials, asking for the deeds. They would include a description of the land, names of witnesses, supporting document, and any other evidence. The government then advertised in the New South Wales Gazette saying that this person had claimed the land and called on people who wanted to oppose this claim. They would then advertise those opposing claims, and they'd advertise the hearing dates, again in the Government Gazette. The court would call on advice from surveyors. Indeed, one of the members of the court was Thomas Mitchell, who was the surveyor. And the court was required to keep records of the land claimed, the memorials received, the opposing claims, and the court's decision. And it's those records that we're talking about today. Now, the courts submitted its reports to the governor via the colonial secretary, and then the deeds would be issued once the governor had approved. So therefore, the Court of Claims is associated with 3 different government agencies, and records spread between those 3. So 1832 to 57, we've got the colonial secretary. Then for 10 years, the Crown Law Officers. And then in 1868, the Secretary for Lands. So as I said, the records can be spread between different agencies. So how would you know that the Court of Claims was involved in something that you're researching, be it a local person or a piece of property, or maybe even a subject? Well, the first thing is you see those words somewhere. You could find those words on a parish map. And here, for example, is the parish of Goulburn, the 1902 edition, where we talk about John Walker, the trustee for the late John Thorne's will, having Court of Claims cases number 481, 442, 372, and 499. So that's an immediate clue, if you like, that you need to look at the Court of Claims. Now, I did notice when I looked at later editions of the parish map for Goulburn that they were no longer using this terminology, and they were just saying that John Walker in trust had the land. So always a good idea to look at various editions of parish maps, because you may just find something slightly different. You might also see the words on a Crown plan. So here we have the Crown plans for those same cases, but we get something extra this time, because we've actually got some alienation branch from the Department of Lands correspondence letters, all dating from 1886, and I've underlined those for you. So here's another little clue that will get us a bit further into our information. As mentioned, there's a lot of gazettal notices about this process. So here we have a gazettal notice in December 1833 for Bernard Williams, 2 grants of land at Londonderry being opposed by Joseph Bolsover. We have this for the hearing date, and in fact the gazettal notice is occurring after the hearing, and it gives us the Court of Claims number. We also have a newspaper article about that same case, and it's talking about John Bernard Williams being opposed by Joseph Bolsover. And it's saying that Mrs. Williams actually sold the property to Joseph Bolsover after her husband's death. Talks about some of the evidence, such as marriage and death notices that came from the clerk of the church. It is actually quite critical of the case. After all, the land was sold by the widow to pay the husband's debts and to bring up her family, one of whom was him. And then there's this amazing little comment. Mrs. Williams sold the land. Pray, did she drink all the proceeds? More on that later. Now here we have for the last Court of Claims case that's in our registers, both the gazettal notice and the newspaper notice. and that's for Elizabeth Robertson, Macquarie Street, Windsor, in 1922. The other place where we might see a reference to Court of Claims, although it might be a little bit obscure, is on a Crown grant. So here we have a reference to the fact that Juliet Lumbey is getting a Crown grant at Wollombi, and there is this number 1010 in the middle of the description with the word report. There's also a note that the land was promised to James Black, who was authorised to take possession on the 5th of June 1831, and he is a disbanded soldier from the New South Royal Veterans Corps. So this number is something a little bit different that we may not see on a Crown grant. And of course, there's also reference to the legislation 5 William IV, number 21. Here we have the grant of land to Elizabeth Robertson in January 1924. A couple of clues here that something a little bit different is going on. Underneath the word grant of land, we've got these words in pursuance of promise and the reports of the commissioners appointed under Part 2 of the Conveyancing and Law of Property Act 1898. Over on page 2, we have again that word, report number 1549, by the commissioners appointed under Part 2 of the Conveyancing and Land of Property Act. And I guess the thing that really might set your antenna going is the fact that it's a 1924 Crown grant, but it cites Governor Lachlan Macquarie as the authority. And Macquarie's been gone from New South Wales more than 90 years, in fact, even probably a lot, possibly 100 years by the time this grant is given. There is an index to the Court of Claims registers on our website. So we'll have a look at that index now. So as with all our indexes, it's available both through the main catalogue page, where you can type a person's name in, but it's also available as a separate index. And the advantage of using the separate index is, of course, that you're looking just at those records, the Court of Claims index, and you can also download entries as an Excel, SV, SCV, or other formats there, as shown by the little tabs that I've circled in red. Now, there's actually two series that are in this index. There's the Register of Memorials under the 1833 Act, numbers 1 to 970. And then there's the Registers of Cases under the 1835 Act, numbers 1 to 1549. There are also 53 references to what's called the additional grants. So this means that when you look at the index, it looks a little bit complicated. So you've got a triplication of numbers 1 to 53. So there's 3 number 1s and 3 number 53s. You've got a duplication of the numbers from 54 to 970. So when you're using the index, it's really important that you note down the date of the memorial or the date of the case and the item number, the microfilm reel number for the index entry. So here's an example of that kind of complication that I was talking about. So Joseph Bolsover, South Creek, Cumberland, case number 243, is an entry under a memorial under the 1833 Act. And all those that are referring to X13 as the item are under the 1833 Act. Janet Templeton, for land near Goulburn, is number 35 in item 2/2370. It's an additional grant. And finally, Elizabeth Robertson. She's again in also an item that starts with the 2-stroke number, and she's under the 1835 Act. Now, if you're having problems with any of this, when you come to the reading room, just talk to the staff on the desk and they'll be willing and able to help you. So what are the record series that we have? To get my mind around how the records worked, I've drawn up this little diagram for myself. And this is why it's important that you note the Act and the year when you're looking at the index, because you're only going to find the entries for the 1833 index in series NRS 913, whereas the entries for the 1835 onwards acts are going to be in series NRS 914. And it is very easy to pick up the wrong one and think to yourself, but wait a minute, this was supposed to be Joe Bloggs and it's Mary Smith. And that might be the reason why, because you're actually looking in the wrong series of memorials or reports. Again, ask staff on the desk if you're uncertain. So let's have a look at the registers and why you might want to have a look at those, even though you're also able to get numbers out of the government gazettes and the newspapers. So again, 2 time periods, 2 registers, NRS 917 for the 1833 Act and NRS 2675 for the 1835 Act. Similar information, the name, the number of the memorial for the 1833 Act, the number of the case for the 1835 Act, the person who's claiming, where they live, who was originally given the promise, the date of the promise, where the land is, information about the actual process, gazettal, date of the hearing, that sort of thing. There is some additional information in for the 1835 Act register, because you often also get correspondence numbers as well, particularly for the later cases when the Colonial Secretary is no longer the agency that is in charge of the records. Here we have an example from the 1833 Act register, and it's the John Bernard Williams case. And again, in this one, we learn that he is living in Prince Street, Sydney, and he's a cooper. The land is 100 acres and 80 acres near Londonderry. And we get the dates of the gazettal notices, the dates of the hearing, that Joseph Bolzer is opposing, and we learn who actually was awarded the deed, and that was actually John Bernard Williams. Here we get an early entry from the 1835 register. Bit harder to read, the handwriting's not quite as nice, but again, similar information as to who's applying, who was previously given the promise of the land, where the land is, and the process that was gone through. And again, we get some correspondence numbers such as CSL 29-88, I think it is, which I presume is a Colonial Secretary re-land letter number, and when the deeds were issued. The 1835 Act, this is the last entries, and you can see from this that you're getting references to correspondence in the alienation branch of lands, also getting references to correspondence in the sales branch of land, and rather interestingly for 1547, you're also getting reference to an equity decree in Suite 7555. So you're also off to have a look at the Supreme Court Equity Court papers. So now we're going to have a look at the memorials and the reports. So the 1833 Act material is by memorial number, and this is memorial number 1, which is Zachariah Thomas Wilcox, who is a soldier, was a retired sergeant of the 39th Regiment, and now is a master shoemaker in York Street, North Sydney. And he talks about who his neighbours are when he's describing the land. So he's not describing it in the same legal way that the land title office might. He's just saying that on the north is Samuel Dick, a general dealer, and he's on the south, my apologies, and on the north is Daniel Hill, a publican. He also lists how he came to have the land. So he bought it for £273 in 1832 from Robert and Mary Day. Mary Day was a widow named Ashton when she bought the land in 1829 from John Flood. John Flood sold the land because he was the executor for the late Henry Robinson. And then you get some interesting pieces of information that you may not find anywhere else. Wilcox believes the original grant was to the late Major Abbott, who sold the piece, now held by memorialist, to one Edward Ryan, who was drowned many years ago by falling into a well. So I think the fact that Ryan's dead is important, but the fact that he actually fell into the well is not, but I can't think of any other place that you might have got that information. The last case in our records, case 1549, and this is under the 1835 Act, so it's a case, is Elizabeth Robinson from Macquarie Street, Windsor. And this was from the Department of Lands, the sales branch, its correspondence. So the land, you get the statutory declaration of Elizabeth Robertson. The land was granted to Thomas Gullidge, but never claimed. It was vacant land at the rear of her and her husband's, deceased husband's property. When her husband George built the house on the property in the late 1890s, he fenced the entire block, the vacant land included, that didn't belong to him. In 1914, council asked him to pay rates and taxes on the vacant block back to the 1890s, which apparently he did. In 1918, he died. And then we get the approval of the court, and yes, they're going to give her the grant. But in order for her to have the grant, she has to pay 20 years worth of quit rent, which amounts to 6 pence per perch, which is an area of land per annum, per year, for 36 perches, therefore £18. And she also has to cover the deed fee, the stamp duty, the Crown Solicitor's cost, and the District Survey Office costs. So she didn't actually get it for free. Now, this is a memorial under the 1833 Act. It's Alex Rutledge, and he's opposed by William Stevens, and he's also opposed by James Eros. And Rutledge talks about the fact that he arrived in the country in 1818, in the colony, I should say. He has occupied the land for 14 years, but he hasn't got a deed. And that part of the land, he gave up part of the land to the government for what he thought was a public purpose, but in fact it was used for Captain Fotheringham's patent slip. And he has something interesting to say in his memorial. Oops, sorry. That in common with hundreds of other grantees, your memorialist, upon faith in the integrity of the government, occupied his grant of land under promise of a deed for the period of about 14 years, till 1832, when in consequence of representations made to your memorialist, relying upon the favour of the colonial government and in the full and undoubted expectation of receiving an ample equivalent, he permitted the use of the land to be taken back by the government. So I guess that's what I find fascinating, is that people are selling and trading and mortgaging without having deeds because they have faith in the government and the governor's promise. And there is a note to say that the land was occupied by Captain Fotheringham. And then we have William's memorial, where he talks about the fact that he originally had a block of land that he was using for his saw pit, and then Macquarie asked to exchange it for another block of land, which he did. And he fenced it, he built up his saw pit on that land. By the way, this land fronts Darling Harbour. And then he went off and did some work for Berry and Wollstonecroft down at Shoalhaven. And when he came back, he found that his neighbours had pulled down his fences for firewood and they'd done injury to his saw pits. And he was then asked to relinquish that block and take another block, which he didn't want to, and in fact, he says he didn't consent to, but next thing he knows, Alexander Rutledge is in occupation of the land. And he also refers to Captain Fotheringham's patent slip, presumably for repairing and building ships. So now we're moving on to one of the additional grants, which is for Janet Templeton. And when I went to the container that had the additional grants, I saw that often present, yet never wanted, little note to say, guess what? 35 is not in this box. But luckily we have Colonial Secretary's Correspondence Reland. We have an index for that on our website, so I went and looked that up, and yes, there was correspondence for Claim 35 in the Colonial Secretary re-land. So it talks a little bit there about Janet Templeton, who is the sister of Mr. Furlong, and she arrived out from Scotland with 9 children. There's some correspondence about the fact that she needs to provide the government with more information about the improvements to the land, that sort of thing. And she writes back in 1843 saying that she's sorry she's delayed, but she was in Tasmania. She resides in Parramatta. It's difficult to get down to the land, and her eldest son works in Victoria. So there is some question about whether or not she is entitled to an additional grant. So now we move on to the 1835 Act, case number 97, which is a grant to Patrick Lysart. And Joanna Lysart, the widow, is applying on behalf of her son, Andrew. And this file also moved forward into 1895 into the Alienation Branch, Department of Lands. What I really like about the 1835 Act is they start putting the case number in very large, big letters on almost every letter. So it's much easier to figure out which part of the file you're after. But again, she's talking about the land, where it's situated, but also who owned it before them. So it's 60 acres. It was promised to Thomas Martin Jr. in 1821. It was sold to Patrick Flynn. Flynn sold it to Owen Boyne. And on the 6th of March, 1829, Boyne sold it to Patrick Lysart for £72 and 10 shillings. And so Andrew does get his grant. Here's a rather interesting case for social historians. Case number 232 of the 1835 Act. Now, who needs soap operas when you've got the State Archives collection? So Margaret Lawrence is applying for the land of her deceased husband, Nathaniel, and she is being opposed by Alice Murphy. So basically, Samuel Terry sold the house and land on the 4th of March 1812 to Nathaniel Lawrence, and it's on the corner of Pitt and Market Street, Sydney. Nathaniel died in 1824, and in his will left the house and land to Alice Murphy, who is now Mrs. Alice Cooper, wife of Daniel Cooper, merchant of London. And this is a direct quote. Nathaniel Lawrence had lived with Alice Murphy for some years previous to his death. So this is the commissioners saying this in the actual report. Margaret Lawrence had a deed of gift from her husband over the property dated the 24th of May 1814, and the commissioners believe this would have affected probating of the will, but there was a subsequent legal document dated 26th October 1816 where Margaret renounced all claims on her husband's property in exchange for £125. The commissioners also state that Alice Murphy had occupied the land since Nathaniel's death in 1825, and she'd spent £2,000 on buildings. So the court decided in Alice's favour. But you get a letter in the file from Margaret Lawrence, who now resides on the Botany Road. And she states that she arrived in 1803 on the ship Roller as a convict with a 7-year sentence. She married Nathaniel in 1807, and she values the present value of the property at £8,000. I do wonder about how some of these people that we've met in these files got through the 1840s depression, which after all was the worst depression Australia has ever seen. So a lot of this court hearings, etc., are just happening in the 1830s, late 1830s, and we know they're about to get wiped out by that 1840s depression. Did they survive? So this is the John Walker case that we've looked at previously. This is another thing that you can actually look at under the 1835 Act, these cases. Sometimes when you actually go to the reports on microfilm, you don't get the case report. Instead, you get a little note saying that it's been moved forward. In this case, we're told it's moved forward to 1867 and 1868, presumably Lands Department. So here you could utilise your skills that you have acquired by looking at our top numbering system webinar and go through all the letter registers to see where these correspondents finally ended up. Alternatively, you can check in our series NRS 8451, which the Lands Department created to obviously try to keep track of these Court of Claims cases. So here from that register, we've got a little note. Half the time it doesn't give the person, the claimant's name, but it does give the correspondence numbers. So in fact, we could now go and look in the alienation branch correspondence for those numbers. And these are the same alienation branch correspondence numbers that showed up on the Crown Plan. So that saves us some time doing our top numbering research. Here we have an 1835 Act, case number 33, James Todd Goodsire, executor for Lieutenant John Rogers. And I wanted to show you this one to show you some kind of what the other kind of documents you can find, not just about the land, but also about the people. So Lieutenant John Rogers is Royal Navy. He says he includes his application for a grant of land. And he says in that he's come from Calcutta in March 1829 by the bark Vesper. He's brought £1,500 with him into the country, remembering we said that you needed to have money to get free grants. And he also has a half pay received from the pension received from the government of £108. In addition, there is another £1,000 in the bank in Calcutta. And we also have his statement from the Royal Admiralty Office saying that he is on half pay and he's allowed to reside in the East Indies, and it's allowing him to reside for a further 2 years, which is something I had never seen beforehand, having read about half pay officers in Jane Austen and Patrick O'Brien, but I had never seen this notice and the conditions that he had to fulfill. So here we come to the case of John Bernard Williams, who is being opposed by Joseph Bolsover, and this is a memorial under the 1833 Act. Now, the land was originally promised to Bernard Williams, who died on the 22nd of April 1822 without a will. He had married Anne on the 9th of April 1810, and she obtained letters of administration for the estate. So basically, she went through the Supreme Court and got letters of administration. Their son, John Bernard, was born on the 10th of March 1817. Now, Anne sold 100 acres to Joseph Bolsover for £40 on the 4th of May 1823. She placed her children in the orphan school, except for one boy who now resides with Joseph Bolsover. And she died 2 to 3 years after her husband. It talks about the debts her husband owed at the time before his death. For example, he owed a debt of $500 on account of tobacco. I presume he was trading rather than smoking. And he also seems to have paid off that debt before he died. And also at the time of his death, he had houses near the Customs House. So what the commissioners are saying is that she did not sell the land because she was in poverty and she needed to look after her children. From all this, and this is a quote, from all this, the inference is that the wife of a man who could readily pay off so large a sum and who had such property remaining at his death could not have been driven by any consideration of her children's interests to sell the land in question, but that it was applied to the purchase of spirits for her own drinking. And if such were her habits and such the state of her husband's property, Joseph Bolsover must have known that he was assisting her to injure her children and herself. So quite criticism of both Anne's drinking and the idea that Joseph has taken advantage of her. So the land was awarded to John Bernard Williams. And here, as part of the evidence, we have the list of the witnesses. We also have extracts done by the clerk of the records of St. Philip's Church relating to the christening of John and the death of Bernard. This is an 1835 case, William Dangar and Hugh Cameron. And William Dangar eventually was granted the land, but I wanted to show you what Hugh Cameron had put forward in his opposition to this. The first of which is a reference that he has got from the people he knows back in Stirling, where he is an iron maker. And all those signatures, it's Stirling, Scotland, and all those signatures plus 3 people saying that they are saying that those signatures are quite correct, including the captain of the 40th Regiment at Hobart Town Barracks and other officials. And then the other thing he includes in the claim is details of what land he has already been promised, the dwelling house that has been erected on it and how much it's valued at, what fencing he has, what clearing he's done, what livestock he owns, and so on and so forth, to show that he is well able to utilise the land. He's not just going to acquire it for speculation, he's going to actually farm it. This one's a little bit different because we've talked about cases where widows and wives are claiming for children, or children are claiming, stating that their mother has sold it wrongly. This is actually one where the original grant was to John Daly Jr. and it's in the parish of Castlereagh. And the grant is eventually given to his father, John Daly Sr. Now, John Daly Jr. was given the grant on the 4th of December 1830. He died about 1833. In theory, the grant should go to his brother Patrick, but Patrick is actually writing, there's his mark, agreeing that the grant should go to their father James because he's the one that's made all the improvements and looked after the land. What I find fascinating is that Patrick describes himself as the eldest surviving son of James Daly Sr. and included with the papers as part of the evidence is a list of all the children. So James, who was born in 1812, has presumably died. John, who was born in 1814, has died. William, who was born in 1815, has died. And Patrick is the eldest surviving son. Infant mortality or accidents, I don't know. Here we have an 1835 case, and this is Juliet Lumbey and James Black, and it's a veterans allotment at Wallumbye in the county of Northumberland. And basically the problem is that it was given to James Black and Juliet bought it from him, but they need a letter from James Black stating this fact before they can give the deeds to Juliet. And by June 1841, he'd left the district. So finally they get a letter from him in October 1841, and he's obviously now back in Sydney. So she finally gets her grant. And our last case we're going to look at today is case number 4 under the 1835 Act, which is Richard Porter. And this is Gloucester and Cambridge Streets, Sydney. And he is opposed by Edward and Joanna Davis. Now, the land was originally granted to Daniel Deasy. He died. Now, his widow is described as not acquiring title to land. What I think this means is that there was no will to probate, and she never applied for letters of administration over his estate. She sold in September 1819 to Thomas Whitaker, who subsequently died. His widow sold to Margaret Quinn. She sold to Richard Porter. Porter died, leaving it to his sons, Richard and James Walker, in England. Porter's wife, Elizabeth, was allowed to live there until she died on the 31st of May, 1835. And it's the executors of Richard Porter's will who are trying to get the deed. Joanna Davis is the daughter of Daniel Deasley, and the court decides that the widow had no right to sell, and therefore none of the other titles are valid. It's only Joanna's. Joanna states that Daniel was asked, that witnesses have told her that Daniel was asked to sign a will shortly before he died, but he would not because he wanted the will to say that the land was hers, and the will didn't. Edward describes how his mother-in-law was utterly inexperienced and was induced by artful and designing persons to sell the said allotment, together with the substantial dwelling house and premises thereon erected, for the inadequate sum of £90, although it can be proved that the property was then worth £400 to £500. And we get the witness statements. Esther Clark says Mary Daisley lived afterwards with a Dr. Lawson, who was drowned. Can't say if she was with him till his death, and he was well off. Also, Mrs. Daisy had a boy at sea, but can't say if he was older than the daughter. And John Flobbing believes that the mother supported the child. She went to live with another man. So, what would I like you to remember? That the Court of Claims applies to Crown grants prior to 1831. Therefore, it's mainly going to be Sydney, Southern New South Wales, Hunter Valley. Two main acts, 1831-35, therefore duplicate numbering. Can get the case numbers from newspapers and government gazettes, but take note of the dates. The index on our website covers 3 different sets of records, so there are triplicate and duplicate numbers. Need to take note of the date and the item that was indexed. And let's not forget about Colonial Secretary Correspondence Reland. Thank you for listening today to our talk about the Court of Claims. Now, there's further information on this topic on our website. So we've got a guide to the Court of Claims, and that's in the Subjects A to Z section of our website under L for Land, along with the index. And don't forget our top numbering explained webinar. That's in the Subjects A to Z section under Getting Started. And you'll find lots of other useful advice in that Getting Started section, including how to read handwriting. There are other guides and webinars on researching land, also in the Subjects A to Z under L for Land. Before we close, I would just like to thank some people who've helped me with this webinar. Firstly, I want to thank the researchers in the reading room who come in and ask us our questions and then share their land research stories with me and often find themselves as examples on these webinars. I would like to thank Dr. Terry Cass for his invaluable advice on land research and his willingness to share the knowledge of land record with the staff at New South Wales State Archives Collections. And I'd also like to thank the New South Wales Land Registry Services for allowing us to include copies of Crown plans and grants in this webinar so that you can see the kind of information they provide. Thank you.